of all the issues that is around us, and particularly the issues that we are talking also are current also. So I am a bit nervy. I am a bit. There's a bit of pressure on me as to how will I do this. And to be honest, I've not done a lot of thorough research as well. So what I'm going to talk is just give you a bit of an idea of what my understanding of the issue is. And I think it's an interactive session, so you'll be asking me questions. But to whatever extent, to whatever knowledge that I have, whatever level of understanding that I have, I'll try to share that. And but I would always say that you should not just rely on what somebody is saying. You should always cross-check that, because whatever one is saying, like in an online meeting or after coming, cannot be. There may be errors, there may be lacunas. So it's always important to cross-check it, and maybe you'll find out, and then find out the exact answer to the point. And also it's important because it will give you, and also it's important to read different views, because then only you will develop an understanding of what is the view on that issue of various people, and finally you'll be able to develop your own understanding. So since it's an interactive talk, I don't know whether I thought that maybe I'll talk a little, 5 minutes of each topic, 5 to 10 minutes, and then each topic we can have an interactive session. So should we do like that, Shobit, or how should we go about it?
Sir, I think I have a set of questions, so it will be easy for you to.
Okay, let's do that. Let's do that in that way.
Yes, sir. So I think the first topic is actually Lakshadweep, but since we are going through pandemic, I think we'll begin with pandemic.
Right.
So the topic is as such as the role of court during pandemic.
Right.
So I think recently even Justice D.Y. Chandrachud, he has actually told that asked the high courts to continue with the e-court system, so as to, because they don't see that resumption of physical courts anytime soon. So first question, I think, sir, is what was the role of courts in safeguarding the rights of citizens during the since the ensuing of the pandemic in 2019 December?
Right. See, it's a very relevant issue to have an understanding of. Also, before I begin, do I need to mix Malayalam and English? Is the crowd?
So you can mix English and Malayalam. So there are no. I don't think there is any non-Keralite here.
Yeah, right. No, because I'm born and brought up in Delhi, so I'm totally comfortable in English. But for the sake of the crowd, if it's required, I can mix it also. Mix English and Malayalam also. That's needed.
You can mix it, sir. I think mixing session is good.
Okay. So if you see, this is a very, very important issue as to what has a role. What is the court? What was the role of the court during this pandemic? Now, if you look, the pandemic started last year in May. In March, the lockdown was announced on March 25th. Now, after that, what did we see? We see a lot of issues turning up. A lot of issues were there. Migrants started moving from the cities. They were moving to their home places, and that was an issue which was there in the public domain. It became a national news. Now the issue was that what did court do at that time? There was a lot of criticism at that time that court did not immediately act on it, but we've seen that courts did play a very major role. And though it may be a little delayed for some people's perspective, but around May Kodati suo moto item. Migrants in their issue, and court had in-depth hearing was done on this issue, and the court said that transportation, food for the migrants should be given. The migrants, it should be ensured, the center state should ensure that they reach the place properly, their hometowns properly, because there was a lot of issues which were there that they were not able to reach properly. They were going barefoot. Lot of things were news were coming out one after the other. So then finally, court suo moto took the issue. Other than that, then we also find during that period the issue of repatriation was very important. മലയാളികളായാലും നമ്മുടെ രാജ്യത്തിലുള്ളവര് പല സ്ഥലങ്ങളിൽ കുടുങ്ങിക്കിടക്കുന്നു. അവരെ തിരിച്ച് എത്തിക്കുക എന്നുള്ളത് ഒരു വലിയ വിഷയമായിരുന്നു. അതെങ്ങനെ അതും കോടതി അത് ഏറ്റെടുത്തു. Court looked at it, was concerned about the issue, and the court eventually decided that and court decided a lot of petitions on that aspect. So there were a lot of PILs which were filed regarding repatriation of migrants, repatriation of the non-resident Indians who were stranded in different places. So whether it is women who are, the various petitions were filed, women who were pregnant, who were stranded. And then there was issues of medical professionals who were stranded. So one after the other, there were one issue or the other which was put before the court. And the court decided it all and said that, told the center that to take steps to bring them back. And as a result, later we saw the Vande Bharat mission also starting with this intervention somewhere. The court's intervention also played a role in that. And Vande Bharat mission starting. So these were some of the major issues where the court played a very important role. As well as one more issue that comes to my mind was where I was also involved along with the organization Pravasi Legal Cell, the issue of airfare refund, where airlines were denying people of a refund of tickets which were booked during the lockdown. So this issue was taken up, though there was initially a notification which only said that those tickets which were booked during the lockdown should be will be refunded. But the point that we raised in that petition was that any ticket, whenever it was booked, but if it was booked for a journey that was during the lockdown, it should be refunded. And the court eventually, in the month of October, passed a judgment saying that refund should be done. So these were some of the very, very important issues where during the first wave, the courts had intervened. Then coming to during the second wave, if you look at it, there were many issues which were there. Primarily the issue was about lack of oxygen, which became the major news. The oxygen ഇല്ലാത്തതുകൊണ്ട് വരുന്ന പ്രശ്നങ്ങൾ പ്രത്യേകിച്ച് ഡൽഹിയൊക്കെയുള്ള സംസ്ഥാനങ്ങളിലായിരുന്നു തുടങ്ങിയത്. അപ്പം the courts played a very important role. They took it up. They saw that there was some mismanagement that's happening somewhere or the other. And then they decided it cannot be done like this. And harsh terms courts were constantly, whether it is the high courts, different high courts, or whether it is the Supreme Court, they raised this point that it cannot go on like this. And finally, a task force was also set up, which has eminent people in that, around 13 people, a force, so that it kind of assists the government and helps them to find out and bring out a proper policy in place. So this has been a very, very major role that courts have been playing. Apart from many other issues the court has got involved in, apart from oxygen issue was in the limelight, but issue of people not getting food was also brought before the was brought before the notice of the Honorable Supreme Court. So the Delhi High Court rather raised a very, very important point in this issue about food should be supplied to anybody who does not have a ration card. Those are the kind of people who are lowest of the lower in the rungs. Those people should get food, and that was also before the court. So likewise, in totality, if you look at it from the first wave to the second wave, the courts have been playing a very dynamic role in bringing out issues in front of the authorities, as well as has been passing directions so that there can be an impact in the lives of people. I hope this much answers your question.
Yes, sir. Yes, sir. So I think sir, SC also appointed a task force to monitor and distribute the oxygen supply to the states in the second wave. Wave.
Yes.
So, sir, does it actually amount to violation of the separation of power, or is it any kind of a judicial overreach?
No, if you look at it, in my personal view, it's not at all a judicial overreach, and that is the view which the judges himself have taken. Justice D.Y. Chandrachud, who headed the bench, which has been hearing the suo motu case, has clearly said that the purpose behind forming such a task force is nowhere trying to overreach or trying to usurp the power of executive in any ways. It is just to create a kind of a mechanism, a consultative mechanism, which will and this objective of the force is that this force will be constantly deliberating and consulting with the government, so that oxygen issue which is there is resolved. The earlier, as we all may know, that ഈ oxygen കൊടുക്കുന്ന ഒരു issue എന്തായിരുന്നു, ഈ oxygen വരുന്ന വിഷയം എന്തായിരുന്നു വെച്ചാൽ government was looking at only hospitals. So they were looking at whether if the hospitals have ICU beds, CCU beds, so on the basis, non-ICU beds, so on the basis of that, they were distributing oxygens to states, on the basis of the number of hospitals as well as the beds. But the court said that cannot be only seen because the pandemic had spread so much and there were people who were not getting beds. So people would be treated at homes. So those people, the issue was that they need oxygen at homes as well. So therefore, the need was that it has to be looked, the whole issue has to be looked in its totality. അതുകൊണ്ട് ഒരു team, ഒരു task force വേണം, and they made a task force with all the heads of premier institutions, medical institutions of the country. Right.
Yes, sir. Pandemic is actually disrupted the normal functioning of the court procedures, like, right? So how did the court actually hear all these cases, and the working of the court overall, how it changed due to the pandemic?
Yes. See, if you see from the period when this lockdown started, courts had stopped functioning. Like all the other institutions, everything had come into a standstill. So the court quickly devised the online mechanism, online hearing mechanism, and thereafter courts were functioning. Courts are still functioning now. Again, it's back to the online, fully online again. In between, when the numbers were less, cases were less, during that time, courts were functioning physically also. But again, courts are now functioning online. So this online functioning is just like the way we are sitting. We are all sitting at our homes, our premises, and we are all together on this online platform. So in the same way, during online hearing, the lawyer is sitting at his place or his office, and he is hearing the judges. The judges are also operating through online mode, but proper hearings are happening. To what extent there can be debate, like how constructive, how much effective it is, but to a large extent, a lot of issues are being getting dealt with through online hearing, which we are seeing right now also during the second wave, during the pandemic also. But major issues of national interest are being dealt through online hearing, and resolution has been done. Yes.
Yes, sir. So, what actually changed from the first wave and the second wave, sir? Like courts, the proactiveness of courts,
Right.
From the first wave and the second wave.
Right. See,
I think courts has become more aggressive in the second wave.
Yeah, as you said rightly, yeah, aggressiveness. Aggressive. I don't know. I don't want to use it aggressive. The word aggressive, but yeah, courts have become more proactive. Probably a little more proactive than they were during the first wave. So as I said, there was a little bit of talk around that during the first wave. That courts, there was a bit of delay in courts and getting intervening in the issue. But in the second wave, immediately courts had started. You will see that as soon as the issue of oxygen, lack of oxygen was there, the courts intervened on it. A suo motu case was taken by Supreme Court. Even before that, the high courts had started hearing petitions. Different high courts started hearing petitions. So major all these issues connected with COVID-19. It's irrespective of oxygen the issue മാത്രമല്ല വേറെ പല വിഷയങ്ങൾ ഓക്സിജൻ ഈ കോവിഡുമായിട്ട് ബന്ധപ്പെട്ട വിഷയങ്ങളിലെല്ലാം കോടതി അത് കേൾക്കുകയും അതിന് തക്കതായ അത് തീരുമാനങ്ങൾ എടുക്കണമെന്ന് പറഞ്ഞിട്ട് സെൻട്രലിനും സ്റ്റേറ്റുകൾക്കും ആഹ്വാനം ചെയ്യുകയും ചെയ്തു. And in strict words, where there was criticism was required, they criticized also that things are not right. You need to look at it. This cannot go on like this. On multiple issues, if you look at what all courts have dealt with during this time, it's not just the lack of oxygen, as I said. It's also the issue of lack of availability of medicines, essential medicines, drugs, which were not there. Whether it is remdesivir, Amplo, I don't remember the exact name, but whether Tosolibum, something like that. You people might know that. So there's another drug which is there. So these, in particular, with respect to each and every drug, also there were cases which were filed and petitions were filed. So courts were looking into it. Even issues with respect to display of boards, digital boards, or rather display of boards with respect to beds availability, oxygen, ventilators, all of that was also heard. that this particular case was filed by me in Delhi High Court, where we said that display boards should be placed in all the hospitals. And the court, Delhi High Court, said that this must be immediately, a decision must be taken by the state. Again, there was another issue which we took it up during this pandemic, was about ambulance charges being very high, cremation charges being very high. So that was another issue. So these are all connected with COVID-19. And these issues were taken up. The court was aware of all this. They said that this cannot go on like this. So the state was pointed out, like, look, you need to step in, you need to intervene, you need to take a decision on this. So Delhi സംബന്ധിച്ച് ഈ ആംബുലൻസിന്റെ വിഷയം എടുത്തപ്പോഴാണ് ഡൽഹി ഗവൺമെന്റ് അതിനുശേഷം നോട്ടീസ് ഇറക്കി, ഇന്ന് ഇത്ര റേറ്റിൽ കൂടുതൽ പാടില്ല. കാരണം ആംബുലൻസിന്റെ റേറ്റ് ഈ പീക്സ് ടൈം ആയപ്പോൾ ഇവൻ 3-4 കിലോമീറ്ററിനൊക്കെ 10,000 രൂപ വരെ വെച്ച് ആംബുലൻസുകാർ മേടിക്കുന്ന വാർത്തകളുണ്ടായിരുന്നു. ഇതിനെ സംബന്ധിച്ചാണ് നമ്മൾ ചലഞ്ച് ചെയ്തു ഹൈക്കോർട്ടിൽ പറഞ്ഞപ്പോഴാണ് ഇങ്ങനത്തെ ഒരു ഡയറക്ഷൻ വന്നത്. So what I'm trying to say is that on various issues, court has got involved. They have taken up these issues. PILs have been filed. They've entertained PILs. They're entertaining PILs on these issues. Again, a couple of other issues, like for example, this is an again issue which we have filed, which is pending in Supreme Court. There are other petitioners also. There are other PILs also filed with respect to this, about corpses, bodies flowing in Ganga. So we all know that how there were dead bodies അപ്പം ഡെഡ് ബോഡിയെ സംബന്ധിച്ച്, അതിന്റെ ഡിഗ്നിറ്റിയെ സംബന്ധിച്ച് ഒരു നിയമം ഈ രാജ്യത്തിൽ ഉണ്ടായിരിക്കണം, ഒരു പോളിസി ഉണ്ടായിരിക്കണം എന്ന് പറഞ്ഞിട്ട് നമ്മളൊരു പോളിസിക്ക് വേണ്ടി, because we can't pray for that to the court to direct the center to enact a law, but we can say that at least look into the issue and frame a policy. So that we've prayed for that in a petition. Again, issue of loan moratorium, the economic problems that people are facing during this pandemic has also been highlighted before the court. So the issue of loan moratoriums have been highlighted. So that those matters are pending. So ഇത്തരത്തിൽ പല വിഷയങ്ങൾ, സമഗ്രമായിട്ട് ഉള്ള എല്ലാ വിഷയങ്ങളും, കോവിഡുമായിട്ട് ബന്ധപ്പെട്ട വിഷയങ്ങൾ കോടതിയുടെ പരിഗണനയിലേക്ക് കൊണ്ടെത്തിച്ചിട്ടുണ്ട്. പലതരത്തിലുള്ള PILs ഫയൽ ചെയ്തിട്ടുണ്ട്. അതിൽ പല PILs ഡിസ്പോസ് ആയി. PILസിലേക്ക് നല്ല തീരുമാനങ്ങൾ കോടതിയുടെ ഭാഗത്ത് നിന്ന് ഉണ്ടായിട്ടുണ്ട്. ഇപ്പൊ പെൻഡിങ് ആയിട്ടുള്ള PILs ഒരുപാട് കോവിഡുമായിട്ട് ബന്ധപ്പെട്ട PILs ഉണ്ട്. So court is actively involved and they are looking into all these issues in a holistic manner. Yes
sir. Now I think I'll give the listeners here a chance to ask questions. Asking any questions you can just raise your hands, and I think your topic the role of courts during pandemic, I think sir can take 2 or 3 questions. Anybody asking any questions you can, any doubts you can, you can please raise your hands.
Hello sir, good evening.
Good evening, Muthu.
Sir, എൻ്റെ ചോദ്യം is regarding ജുഡീഷ്യറിയുടെ പല സമയത്തുള്ള ഓഫ് ദ കഫ് റിമാർക്സിനെ പറ്റിയിട്ടാണ്. So even in Madras High Court had recently made a statement about the Election Commission and its role in COVID, which Supreme Court has very seriously criticized. Supreme Court in its judgment said the judges should be very careful while making the off the cuff remarks, especially about constitutional institutions. So ഇത്തരത്തിൽ കോർട്സ് പലപ്പോഴും നടത്തുന്ന ഈ ഓഫ് ദ കഫ് റിമാർക്സ് നമ്മൾ ഉണ്ടാക്കിയിട്ടുള്ള ഒരു ബാലൻസ് അതിനെ വല്ലാതെ അഫക്ട് ചെയ്യുന്നില്ല. ഇപ്പൊ പലപ്പോഴും കോൺസ്റ്റിറ്റ്യൂഷൻ ഹാസ് എൻവിസാജ്ഡ് ജുഡീഷ്യറി, എക്സിക്യൂട്ടീവ് ആൻഡ് ലെജിസ്ലേച്ചർ ഓൺ equal power, not as judiciary as the overarching institutions above the other two. ഇപ്പോൾ ഇത്തരത്തിൽ ഇലക്ഷൻ കമ്മീഷൻ ഷുഡ് ബി ചാർജ്ഡ് ഫോർ മർഡർ, അല്ലെങ്കിൽ ഡൽഹി ഹൈക്കോർട്ട് മേക്കിംഗ് മെൻഷൻസ് ദാറ്റ് യു മേ ബി ബ്ലൈൻഡ് ബട്ട് വി ആർ നോട്ട് get the oxygen by steal or loot by any manner. Chief Justice, Supreme Court saying, wake up and smell the coffee. How far, is this kind of, approach from the judiciary sustainable, especially when we have a democratic system of government where the executive and legislature should be taking, there should be mutual respect, at least in making such remarks. Court is very well within its rights to give written orders, but how far this kind of an approach is sustainable? Especially former Chief Justice as R.C. Lahoti had written an article saying that judiciary must uphold citizens' right without sacrificing sobriety. So isn't this judicial sobriety and restraint a necessary factor while making such judgments, especially in the wake that we are going into an e-court system where the live proceedings will be visible to every citizen? And so if this is the case, the thug life videos of judges will be soon out saying, such comments.
Right. Got the question, Vipin. See, it's interesting. What you've raised is a very interesting issue. But see, the whole thing here we need to understand is that we are going through a pandemic scenario, and this is like never seen, like unprecedented, and very exceptional times that we're going through. And what did we see during this time? We saw that there were initially we saw a lot of images, a lot of news, which were very, very disheartening, which was very deeply filling us with pain and as well as tension as to what is going to happen. We saw that people are not getting beds in hospitals, there were oxygen supplies shortage, and all these issues connected with that. Day in and day out, we were reading, hearing, and it was affecting all of us. And it's same way, I'm sure it has gone into the minds of the judges as well. So they also saw that this is a very, very desperate kind of a situation where people are all feeling very helpless, and this is the time when probably from their end also they need to be a little more tough. And it could be because of that. One can go into the psyche of the judges and find out why did they say such kind of remarks, and there will always be a debate, like they should not have said this much to that extent. But what I understand is that since we've seen a lot of high courts making such kind of strong remarks, it's because of the fact that the scenario that we are facing is really a big, daunting, very tough, വളരെയധികം ചിന്തിക്കുന്നതിന് അപ്പുറമുള്ള ഒരു വലിയ പ്രതിസന്ധിയിൽ കൂടിയാണ് നാം കടന്നു പോകുന്നത്. അപ്പം that is the reason why they wanted the executive to kind of react quickly. And when they make a statement, it will always be a national headlines. It will go there, it will reach the ears of the authorities, and more than a protest or more than anybody sitting there. So impact will be there. So they also realize that, and that is the reason. More or less, as you said, times have not changed. Now what we are seeing is that everything that the courts make a statement or any hearing that is happening, an important matter which of national interest, it gets into the media very quickly. Social media is there, right? There are minutely updates coming of hearings. Live hearing updates are coming. We've never heard this before. Like say about 5 years before, there was nothing like this. So now everything is so lively, and so it's there. It's been getting updated on such seconds and minutes manner. So yes, then the question comes that should there be not a bit more be careful about what we say and how much we say, to what extent. But then let's look at it in the aspect of being in the middle of pandemic and really a big war-like situation where the country was. So it was time to just, everybody was in that tension and heat. So probably these remarks have come because of that also.
So, but doesn't the Attorney General's remarks in the court during the hearing also hold some merit, that during unprecedented times, unprecedented action may be required from the part of the executive, and an executive body which is functioning day and night, using all kinds of tools like diplomacy to get in oxygen, can a judicial chamber that works from 11 or for a very few hours can match the effort being put forward by the executive? So isn't it, forming groups like the empowered groups by themselves, isn't it amounting to judicial governance? In a democracy, how far judicial governance is something suitable?
Vipin, that's what, see, the issue is very debatable, and it will have people of both ends, some supporting it, some not supporting it. Those who are within the system, within the judicial system, would say that, yeah, see, the courts felt that they need to step in, because somewhere to some extent we all know that how the lack of oxygen or lack of beds in hospital, these are all issues where it gives an impression that, look, things are not working well, there's some kind of mismanagement that's happening. There has to be the judiciary, and when petitions are continuously filed, one knows that how the courts are burdened with so many PILs, so many petitions are coming before the court, and the courts are burdened with it. And and it's not just burdened, but they feel the necessity, that they feel that people have a genuine problem they're facing, and they're coming before the courts now because they feel helpless and they want the courts to intervene. So on that count, these kind of responses do come out. So, but yeah, and let's look at it in the aspect of this pandemic. I don't think so. Before this pandemic, we've seen courts giving such kind of passing such kind of remarks to this extent. So this has happened in the midst of this uncertain, rather exceptional times. Because of these exceptional times, these kind of remarks have come. Let's look at this way. And yes, and the courts are totally aware that there should not be an overreach. I think Justice Chandrachud, Honorable Justice D.Y. Chandrachud, has himself said that when he formed this task force. That's something which I'm reiterating. When he formed the task force, he said that we are not trying to overreach. We are not trying to. We know that, but what are the roles? Each pillar of the democracy has their roles, and we were not going. We are not overreaching. We have no intention to do that. We know it's not right. It's not. It's constitutionally invalid, and they will not do that. But what we are trying to do is just trying to build a bridge and trying to facilitate things so that things get better for the people.
Sir, I had one more question regarding the collegium system, which is much more debatable than the current issue. With the Supreme Court has struck down the NJC judgment a few years back. But even during that judgment, Justice Chelameshwar had made some remarks. He wrote the dissenting judgment saying that collegium is one institution which is opaque like anything. So how far the judiciary can lecture on transparency, accountability, and the need to avoid nepotism, etc. When the institution itself is sitting upon a very opaque system like the collegium system. So isn't it the time to shift to something very positive? Of course, the memories of 70s and 80s may be there, but haven't we come so far from that period wherein we should be thinking of a system much more transparent and accountable?
So let me interfere. I'm interfering because I think this question is again we have a topic called Legislature and Judiciary. I think the NJC issue we can take it up there rather than. I mean the question we can address it later when you talk about the Legislature and the Judiciary.
Okay.
The role of courts during pandemic. If any other questions are there, I think you can raise it now. I think Vibin, your question falls under a different topic.
Okay, sure.
I will take it.
Okay, fine.
Yes, anybody else who want to ask a question on role of courts during pandemic, or shall we move to the next topic?
So there was the news on e-courts
Yes.
being implemented. So is there there are many criticisms going on e-courts? What are the limitations on running an e-court in India?
Right, that's a good question. See, e-courts, there are discussions going on. There are discussions regarding the effectiveness of e-courts in certain parts of the country. Like, as we all know that India is in the process of becoming a digitally powerful nation, or maybe a digitally accessible nation, rather to be better, which is accessible to everybody. So even now, there are areas in the country, there are remote areas, maybe district courts which are functioning. If they have an online system properly, there are technical glitches that advocates are facing while attending hearings. So this was recently raised up also by the High Courts, and Supreme Court, I think, they have made a passing reference about this in some of the matters as well, like that this has to be, the issue has to be dealt with. So there are committees which have been formed, and they are looking into it so that the online hearing is effective as it is in cities.
Yes, sir. To add on to that question, I think, sir, I heard something called an ecosystem approach that is being taken in this e-courts system. I didn't quite catch what it is. I was reading the newspaper yesterday, and I found a term like in the e-court system. There is something called an ecosystem approach. I do not know if
it probably is a kind of a system which facilitates those to create a system which facilitates those who are not technologically advanced, or maybe technologically they're a little backward. So it's a kind of developing a system mechanism which will be more conducive, which will be more helpful for all kinds of lawyers, because you know that lawyers is a fraternity where you have all kinds of people. Like there are different age groups of different people have come from different strata of society. So there will be people who will be really well aware of all these technical know-hows, and they will be very good at it. But there will also be people from different strata of society, as I said, remote areas of the country also, who are not probably well equipped to handle the present system, online hearing system, which is there. So this is a topic which is going on. The discussion is going on. Let's see something works out, and a system is developed which benefits people from all stratas of society, lawyers of all stratas or litigants of all stratas of society who probably are not very technologically advanced. But there's no need for rapid technological advancement. But even though at the same point, I would like to also add that there are tutorials also which are there on the sites, Supreme Court, High Court sites. So they're trying to so that people are aware of how things are to be done, how filing is to be done, how hearing is to be attended. So they're trying to make things easy, but still, if there are, because the issues have been brought into light, especially with respect to connectivity, network issues, connectivity are these major issues. So I think all of this will be dealt with the high-powered, empowered committees which are going to be formed.
So being a practicing advocate, how do you see the present, virtual hearings that are going on? Because many a times when I watch this proceedings in Gujarat High Court, which is there in the YouTube, we can see that many a times the judges making, remarks about maintain your volume, this thing, that thing. So does that reflect, that judges as well as the advocates are facing these technical glitches, technical awareness issues while facing this digital hearing? What are the major issues? Because you recently also the Chandrachud committee had presented its report on e-court hearing. So it says that when we are hearing certain communal issues or certain sexual exploitation cases, that should be muted. So how prepared is the present system to make such changes? I was just curious to know what is the platform being used right now for these hearings.
Yeah, it's good. These questions are coming. I'm expecting these kind of questions because you have to expect it when you're talking to UPSC aspirants. So if you look at it, the online system that is going on, the hearing system which is going on right now, varies to court, varies from place to place. But as far as from Delhi is concerned, there is Cisco WebEx, which is there. This is the app which has been used by Delhi High Court. So hearing links are shared a day before, and from there we attend the hearings. So that's how we do the hearings. And the process of hearing is not difficult, but just have to enter, press the link, you directly, and you get facilitated. There are moderators also who are sitting and they help you with the hearing process and everything. The only issue, as you also pointed out, your question was that technical glitches. Yes, there can be, and that depends like where you're sitting, because of the network issues and connectivity. But overall in Delhi, the situation is not bad, and because network issues are not there as that much. I mean, people are not facing that much of network issues and connectivity issues. So Delhi, the issues are not much, but in other areas, definitely there are issues with respect to network connectivity. That's number one. Now, as far as the other issue that you said was with respect to e-courts, functioning of e-courts, how effectively we need to make sure that the functioning is effective. What should the court do for it? In that, as you said, that this is all before the notice of courts. Mr. Chandrachud himself has submitted a report, as you rightly said, and there's an e-committee which is also there in Supreme Court. So they are looking at all these issues and how to make the hearings better. But each court has got their own different ways of conducting it. They use different softwares to conduct these hearings. Like Supreme Court uses video test. There's this video conferencing, VIDYO. So they use that software for their hearings. So they also send their hearing links to the AOR, the advocate on record, just a few hours before the hearing, and then they attend it. So this is the whole system that is at present, at least in Delhi High Court and Supreme Court, the way they are functioning right now.
So, but shouldn't the privacy concerns should be respected? After this Juhi Chawla case where the fans came in and disrupted the proceedings of.
Yes. I was about to say that is a very important thing, which is very wrong. Which has happened, and that video got viral, it's got circulated everywhere, and it showed, and that's why the courts took it very. They took it very harshly, and they imposed a huge fine, as you know, 20 lakh rupees on that PIL, because the courts really were not happy because the fact that, and they felt that it was more of a publicity, nothing more. This was sent around in social media, and it was quite surprising that somebody like a celebrity like Juhi Chawla and a petition which did not look frivolous. It said that about radiation, and she's somebody who says that she's been working on this issue for some long time. But then, since this got on social media, you know that people will join in, and everybody's curious to know what is happening in courts, and they all jumped in, and then it got there was a mess.
Yes, sir. Since we've been brought it up, I think we'll move on to the topic of legislature versus judiciary.
Right.
So I think, sir, uh, could you please say what is the difference between judicial overreach from an advocate point of view? What would be judicial activism and what would be judicial overreach?
See, this is a very difficult concept altogether, but then there can be lengthy discussion on this, but I will try to just put it in a very layman manner. What is my understanding? See, judicial activism is more in a positive sense. You can take it where the courts are trying to interpret laws in such in a beneficial manner, so that it is more beneficial for the people. So then therefore they try to reach, and there's no overreach as the word is saying, because it's more seen in the form of an activism. Like, for example, when in Justice Bhagwati's time, when PIL was introduced. Now PIL has come as a big milestone when it comes to judiciary's ambit and its involvement in public issues. So with the reach of PIL, there is a segment who will say that no, look, it's more of a judicial activism, over activism, and hyperactivism, or whatever they can say that. But then we can see so many issues judiciary has dealt with the coming of PILs, with the advent of PILs. We see that pala issues. MC Mehta pala case MC Mehta is a famous environmentalist who has, through using this tool of law, has brought in lots of issues before the glare of court. So അങ്ങനെ പല ഇഷ്യൂസും ജുഡീഷ്യൽ ആക്ടിവിസമായിട്ട് കരുതിയിട്ടുണ്ടെങ്കിലും അത് പിന്നീട് അത് നമ്മൾ ചിന്തിക്കുന്നത് അത് കോടതിയുടെ ഇന്റർവെൻഷൻ ഉണ്ടായതുകൊണ്ടാണ് ഒരു ഇമ്പോർട്ടന്റ് ആയിട്ടുള്ള ഇങ്ങനെ ഒരു വിധികൾ such kind of decisions came out, and it led to very historical changes also, or for that matter law making also. So that is judicial activism in my view. But judicial overreach is more of a negative way, which you see as a term which is seen as in a more negative sense, where you see that people see this, and also it's widely perceived to be a method by which judiciary tries to overreach or tries to get into the domain of executive and legislature. Now, when that happens, then it is considered to be wrong. Because we all know that what are the powers of executive, legislature, and judiciary. Executive has got its power of making policies, of implementing policies, so they've got their powers. Legislature enacts laws, and judiciary administers justice, and it administers whether the law is constitutionally valid or not. It's got that power. So there is a clear demarcation of powers. Now, in this sense, if there is if judiciary is trying to get into the power, or is trying to, if you want to use, but I don't like that word encroach, but if it's trying to go into the domain of the other pillars, then it is judicial overreach in my view. And there are examples of judicial overreach which you all know, which is considered to be judicial overreach. But this is the clear distinction between judicial activism and judicial overreach.
Yes, sir. So, basic structure doctrine. It was actually, I think, it was a court's invention of the courts, right? So, how far it is effective in limiting the powers of the parliament to amend the constitution?
See, basic structure is a very, very important doctrine. Very, very important doctrine that anybody, irrespective of whether the person is from the field of law or not, but should have an idea of. Now, before understanding the basic structure doctrine, one has to look at the context of this judgment. Why was this judgment filed? This judgment, as we all know, was filed. This petition was filed because of the Kerala Land Reforms Act and the amendments that were happened in the Constitution, 24, 25th, 26th, the 3 amendments which happened. So it was precisely against the amendments as well as the Land Reforms Act which was there, and how it is not right on the part of state to To it violates the right to property. So those were issues without giving a fair, which is against the principles of natural justice. So on those grounds, this petition was filed by Keshavan Gandhi. But and this judgment, which was passed by these 13 judges, is a landmark judgment because of the fact that it brings in this very concept of basic structure. And because of the result of this basic structure doctrine, the amending power under Article 368 of the Constitution, which gives a very wide power and which does not spell any limitation in the power of Parliament, the courts felt that there needs to be an inherent limitation. Power needs to be limited. And that is the reason why they decided to bring out this basic structure doctrine, which has been refined with time. There are no set number of points which come under the basic structure doctrine. If today there are X, tomorrow it can increase. So, but as you all know, what are those basic structure principles which have been, which are there, with Justice Sikri at that time and the 13 judges who were there, 7-6. This judgment held that the constitutional power, it actually, if you look at it, if you look at the context of, as I said, look at the context of this judgment, you need to understand the Golaknath case. The Golaknath case, which was filed, only said that it comes within the ambit of legislative power. The amending power of the Constitution, of the Parliament, the amending power of Parliament is basically part of legislative power. But the Keshavan Bharati case clearly said that no, it is part of constituent power. The legislative power is there, but which comes under the Article 13(2) of Constitution. But that is separate. But the constituent power is different, and the constituent power under Article 368 will have its limitations. Inherent limitations will be there. That is what they said, and those limitations were spelled out one after the other. Supremacy of the Constitution. I think you all know that the separation of powers. Likewise, judicial review was subsequently added to this list. Then there were secular sovereignty of the nature, democratic quality of the country. Welfare state was also said that on the basis of directive principles of state policy, the state there should be welfare state. The secular nature of the state. So all these pre and pair elections were later on added. So there are a list of doctrines, a list of ingredients which are part of the basic structure doctrine. But when you ask me if it is, if it curbs the power of Article 368 which grants the power to Parliament, yes, it does. But why it's required is because the basic structure is, if it was not there, then it would have created a lot of problems. It could have created a chaos, and it could have also diluted the separation of powers.
Yes, sir. In any way, is this basic structure doctrine negative on the Constitution? Does it have negative implications for the Constitution or overall for the country or the nation?
See, I will not say that that it has negative implications in any way, because I, for one, is somebody, not just because I am part of the judicial system or being an advocate or an officer of the court, but also because generally, as a citizen of the country, I feel that it has brought positivity. It has done more good for the citizens than probably any harm that anyone would like to say. Probably a lawmaker would like to say that no, look, our power has been curbed and this is not done. We had the power; it was not spelled in the Constitution. We had the power to make laws on anything or everything under the sun. But I do not agree. I think that there was a need for a limitation, which was there, because then only then can the rights, the human rights, and the essential rights of people will get safeguarded. And so therefore, the basic structure doctrine is very, very essential in my perspective. But it's always good to have two sides of the coin, to look at it more positive than anything negative.
Yes, sir. So which brings us to my next question, and I think Vipin has already raised this. What was the rationale which Supreme Court used to strike down the NJAC? If I remember correctly, I think something like primacy of judges was used.
Right.
Principle called primacy of judges was used, but unheard of before that, I think. What was the rationale, sir? The Supreme Court actually
Yeah.
used to strike down NJC.
Another very, which is a hot topic around 2014, 2015, this was a very hot topic of discussion. And we know that with the 99th Amendment and how there was this decision by the executive, by the legislature passed the bills stating that there should be a reform now. The collegium system cannot go on. There has to be a reform. So they formed the NJAC, the National Judicial Appointment Commission. And this commission, as you all know, was a 6-member committee which was formed, which had the Chief Justice of India, the Law Minister, which had which had another 2 expert people, the two Supreme Court judges, 3 plus 4. So you already have Supreme Court Chief Justice, you have 2 senior judges of Supreme Court, you had the Law Minister, and then there were 2 experts who will be part of this, who will be selected by the committee of Prime Minister, Leader of Opposition, as well as the CJI. So this was the whole structure of the NJAC. But then the courts felt that this was not appropriate. The 5 judges bench, which heard this matter, headed by Justice Kehar, former Chief Justice, he said that this is not the right methodology. And why was he against it is because he felt that the bench felt that, the bench felt that 4:1, they felt that this is going to impinge, or it is going to affect the independence of judiciary. And therefore, they decided that no, it cannot be allowed, because separation of powers is a basic structure doctrine, and something going against it. It is totally not right, and it is unconstitutional. So the fundamental reason for declaring the constitutional amendment and the NJAC Act as unconstitutional was because it impinges, it affects, or it hits the constitutionally guaranteed the basic doctrine of separation of powers. So this was very, very clearly enumerated in this particular judgment. And it also looked at the 3 judges case, and it looked at the 2nd judge's case thoroughly, where it looked at how consultation is concurrence, and the judges should, the Chief Justice of India will have primacy over others, and in the collegium system, everybody is of judicial background. So somebody, when you have an NJAC, you will have people who will be selected now. You have people from different, maybe not a legal background, so they will also be involved, and they are appointed by executive, and that will have an effect, because that shows that the executive will have an involvement in this appointment process, and therefore it will affect the independence of the judiciary. Yes.
Yes, sir. But I think, sir, we know that the collegium system is not that a transparent system. So, is collegium the right way to appoint judges? I think appointing judges is a system that is not seen nowhere else in the world, right?
See, for somebody like who's an 8-year-old in the profession, and if I'm going to make a remark on certain of these topics, hot topics, and topics which will have wider implications, I have to be very careful of what I say. But I mean, at the same time, see, personally, a lot of people, a lot of erudite, a lot of scholars, legal luminaries, they've all said, including the Attorney General of that time. Obviously, he is the Attorney General, so he would favor the bill and the act, and he would support the executive. But yes, he himself said that after the judgment was out, he said that the decision has come, but I'm personally not happy with it, because he and many others have heard that they were in favor of a reform. A reform is needed, is what was the general opinion of legal luminaries. Because my view doesn't matter much. What is there in the public domain? What has legal luminaries said about it? What was the viewpoint at that time? That is something which is more important. So from that perspective, you will see that there is a segment who said that if you are not saying NJC, then you should bring out something which is more, which apart from this collegium system, which in place of this collegium system, is what was a large view.
Yes, sir. So I think if anybody else have a question on this regard, please, you can ask it now.
Sir, as an add-on, doesn't citizens have the right to know, why Supreme Court takes certain decisions? Recently regarding the transfer of Justice Tahil Ramani from the Madras High Court to Mizoram, so nothing was put in the public domain as to why such decision was made. So it send a message that Supreme Court is dealing everything in a in a dark corner where nothing is put it in the public light. For example, when the collegium considers the name of certain High Court judges for the appointment to the Supreme Court and then says that they are not eligible for that, they does not put any reason for that, and these judges still continue to be High Court judges. And also, I had one more question regarding the removal of the judges. We have so many instances where corrupt judges, they were allowed to resign and still they are taking the perks of the government, including Justice Dinagaran and Justice Sen of Calcutta High Court. So, on both these issues, if your views are not.
Mr. Vipin, it's again a very valid observations that you're making from your end. When we look at it, any layman would look at it in that perspective. That why are things not there in the public domain? Certain issues, people want to know about it. Why is not there in the public domain? How is it possible that it's been done like that? And then indirectly, somewhere we are coming back to the point of opaqueness, which is there that you wanted to point it out. You yourself pointed out. But then we need to look at the aspect of why is this happening? When you ask this, it is a system which has been followed on. This is not something which has just been started off right now, which was there, and we should start independence as a judicial system has been set up. Now, when we see that this has got passed on and the system has been continued, so there has been elements like which needs rectification. That is, with time we need rectification, and it is only when there is a proper, when issues are raised in the right manner and when it is put into the public domain for discourse, for proper deliberation, only then can things will be there. I think when you bring it to the national fora for discussions, and then when this was brought by good organizations, proper organizations bring it on, I think then when it will come to the public domain, there will be rectifications which are necessary. That's what I can say, which is the need.
Yes. Anybody else wants to ask a question? In that case, I think I will move on to our next topic, sir.
Right.
I think it is Lakshadweep. I'll move on to the first question. What is the current status of the Lakshadweep issue in respect to courts? I mean, has the court actually taken up a case with the current status of what is happening in Lakshadweep?
Right. I think we all know that the Kerala High Court has got jurisdiction over Lakshadweep. Lakshadweep, this union territory, has now all of a sudden come into the national limelight like never before. The national media is on a day-to-day basis. We are hearing something or the other about Lakshadweep. Now, the courts, to come straight to it, specifically to your question, whether the matter is pending in courts, yes, the court, Kerala High Court is hearing this matter. There are petitions being filed one after the other. As per my knowledge, there are petitions which are filed one after the other. There is a few petitions which are pending as well. I don't know whether my information is accurate, but I do know that there are petitions which are pending as well. Now, what were these cases which were filed in the Kerala High Court? There are cases which have been filed against the draft legislation, the Land Lakshadweep Development Authority Regulation 2021, against it, so that there is a stay on this draft legislation. But there is no stay right now, as per my knowledge. The matter is pending. The court has issued notice to Centre, and they have asked them to give their response to this within a specific time, and the matter is pending. Within a specific time, they need to respond to this particular petition, to the notice that has been issued. Then there have been petitions which have been filed with respect to. There was a petition which was filed about COVID SOP, which was filed in Kerala High Court, stating that the SOP was changed, and this was not, and the direction that was issued by the administrator with respect to RT-PCR test negative report before 48 hours, that is enough for entry. That is not right. But the court said that that's a policy matter. And whatever has been done by the administration has been done considering administration so they did not interfere. Case The issue was about uh, evacuation, medical evacuation. Like if there are people who are medically ill and they need to be evacuated from an island, what should be done? So the health department of Lakshadweep had formed a committee. Now that committee has been directed by the Kerala High Court. The High Court has given 10 days time to formulate a guidelines. They said formulate a guidelines how you will be evacuating a person from an island and how will you be bringing to another place, say for example Kochi or any other ആ സ്ഥലത്ത് ട്രീറ്റ്മെന്റ് എങ്ങനെ കൊണ്ടുപോകും തിരിച്ചു കൊണ്ടുവരും അതിനെ കുറിച്ചൊക്കെയുള്ള 10 ദിവസത്തിനകത്തിൽ മറുപടി തരണം എന്ന് പറഞ്ഞിട്ട് ആ ഒരു പെറ്റീഷൻ ഇപ്പം പെൻഡിംഗ് ആണ് കേരള ഹൈക്കോടതി. അപ്പൊ അങ്ങനെ പല തരത്തിലുള്ള ഇങ്ങനെ പല വിഷയങ്ങൾ കോടതിയുടെ പരിഗണനയിൽ എത്തിയിട്ടുണ്ട്. അതെല്ലാം കോടതി പരിഗണിക്കുന്നുണ്ട് എന്ന്. പിന്നെ ഡീറ്റെയിൻ ആയവർ ചിലർ ഡീറ്റെയിൻ ആയി അപ്പൊ അവർക്ക് ജാമ്യം കിട്ടിയില്ല, അപ്പൊ ആ വിഷയം അവർക്ക് ബെയിൽ അനുവദിക്കണം എന്ന് പറഞ്ഞിട്ട് ഡിറ്റൻഷൻ ഓർഡർ ശരിയായില്ല എന്ന് പറഞ്ഞിട്ട് അതിനെക്കുറിച്ച് സംബന്ധിച്ച് കുറെ പെറ്റീഷൻസ് എനിക്ക് കേരള ഹൈക്കോടതിയിൽ യൂഷ്വലിയൊക്കെ വരുന്നുണ്ട്. അപ്പൊ അങ്ങനെ ഈ ലക്ഷദ്വീപിന്റെ ഇഷ്യൂ ആണ് ഇപ്പം പ്രധാനമായിട്ട് ഒരുപാട് കേരള ഹൈക്കോടതിയിൽ പെൻഡിംഗ് ആയിട്ട് പല വിഷയങ്ങളും വരുന്നുണ്ട്, ഹൈക്കോടതിയുടെ പരിഗണനയിലുണ്ട് എന്ന് പറഞ്ഞുകൊണ്ട്.
Oh, okay, sir. So I think you have already also said about the role of courts handling such issues related to administration of union territories, right?
Right.
What are the role of what are the roles of actually the High Court? I mean, it is just like the Kerala High Court. It is just like Kerala High Court has jurisdiction over Kerala. It has also jurisdiction over Lakshadweep, right?
Absolutely, absolutely. It has jurisdiction over Lakshadweep. We all know that. There are 24 high courts, if I'm not wrong. And as far as union territories are concerned, only Delhi is the only union territory which has its own high court. The rest of the high courts are affiliated, or the states which are nearby to it have jurisdiction of on that union territory.
Even related to the government and administration, also the jurisdiction is actually to Kerala High Court, right?
Right, right.
So, sir, is it valid to challenge the executive orders related to UT in court, or if court interferes, does it actually amount to judicial overreach?
See, what we need to understand is, again, we are coming back to that issue of judicial overreach and separation of powers. So it's got an connection with that issue. So ഇവിടെ നമ്മൾ മനസ്സിലാക്കേണ്ട ഒരു കാര്യം, ഇപ്പം കേരള ഹൈക്കോടതി ഈ വിഷയം എടുത്തപ്പോൾ ഹൈക്കോടതിയുടെ ഒരു സ്റ്റേറ്റ്മെന്റ് ഉണ്ടായിരുന്നു, പെർട്ടിക്കുലർലി വിത്ത് റെസ്പെക്ട് ടു ഒരു നോട്ടിഫിക്കേഷൻ റദ്ദാക്കണം എന്ന് പറഞ്ഞിട്ട് വന്ന ഒരു വിഷയത്തിൽ, which was about this COVID SOP only. When this issue was brought in, like court has said, like only when there is an order which is illegal, arbitrary, or perverse. These are the three words which has been used: illegal, arbitrary, perverse. So when there is such kind of a direction, such kind of an order, the courts will probably decide to interfere in the issue. Otherwise, the courts will say that, look, as they said in this particular SOP matter, the courts will only say that the administration has the power to decide on a matter. It is a policy decision, so let them do it. They've got the machinery, they are empowered, and they are supposed to make the policy. They will be doing it. So the courts generally say that only. That is the stand, and not just in this aspect of issue of Lakshadweep, but in any issue that we see recently during this pandemic also. I personally know that I've attended hearings where courts have declined to entertain PILs which are policy related. So they say that this is a policy matter, we cannot entertain this matter, and then they decline to entertain the petition. So the courts are very well aware of the clear demarcation of power which is there.
Yes, sir. One other thing is that in in Lakshadweep, I think in 2019, the NCRB, the Crime Records Bureau report, it says 0 cases of murder, kidnapping, or anything. So there are, but new criminalizing acts are actually being brought up in Lakshadweep. How would the courts view this, sir? Or is it,
Yes.
Is it like that the executive can do such things? The court will only interfere if there is actually a case.
I think are you trying to refer it with respect to the Prevention of Antisocial Act that they have passed also? I think it's on connected with that, right? which is called the so-called Gunta Act that
Yes.
So that there is this, as we all know, a lot of issue has been raised about this with the Save Lakshadweep hashtag, and especially in our state in Kerala, we know that how a resolution was also passed, was supported by the opposition, the government together, they collectively passed a resolution. So, and all these the important laws have been brought into the public domain, and they've been criticized, and they've been very minutely been scrutinized. Whether it is the Lakshadweep Development Authority regulation, whether it is the Panchayat, the Prevention of Anti-Social Activities Act, or whether it is a Panchayat notification. It says that a person cannot stand for an election if he has more than 2 children. So these issues have all been there in the public domain. And as far as this Prevention of Anti-Social Activities Act is concerned, yes, you are right when you say that, and everybody knows that Lakshadweep is considered to be a very beautiful state and very peaceful state. So the crime records does say that. But then why then there is this Prevention of Anti-Social Activities Act? That is the big question that has come into the public domain. So the people who support it, the administration says that since the administrator took charge and this regime change, they have seen that there are a lot of incidents of crimes that have happened which go unreported. Now, how far that is true or not, is somebody sitting here or we sitting at different places, we don't know. Unless we go there and know the ground reality. But they say that there are cases which are going unreported. But as far as the official records are concerned, we rely on the records, and the records say that no, look, there are no crimes as such. There are no anything major or anything which is worth noticing. There are no any grave crimes that have been committed. So why then? So that question is there. But the side, we need to look at both sides. Why this has been enacted? What is the situation? What is this view of the administration? What is the view of the people, residents of Lakshadweep, who are against the administration, or the people who are against this? So why are they? So we need to look at both sides of it and then understand it in a holistic manner.
Yes, sir. So there is a clearly differing opinions between islanders and the administration right now. So how far the courts can actually the courts can find out an amicable solution in this issue, or does the court have a very big role to play here, or is it more of a government thing?
Look, this is a complex issue. Complex issue in the sense, Lakshadweep was not in the news before, but Lakshadweep has now come in the news, and now the issue has suddenly reached the level of administration change and issues with respect to some administrative reforms, or for that matter, laws, rules, all of that are there. Now, what is the power of court in this? Now, look, if you look at it, we are seeing the approach of the Kerala High Court here has been that they are not, as we discussed also, judicial overreach. They are not trying to overreach here. They are not saying that, look, just remove the administrator, or look, this cannot be done at one go, pass an order. They are not doing that. They know that it's not right. It cannot be done like that. It's not permissible to do that without looking at the whole issue, without giving an opportunity to the center to come out with their view on this. And that is the reason why, if you look at it one at a time, the first issue that I just said was about the draft Lakshadweep Development Authority regulation. So what they've done is they've issued notice to center. They've told center, tell us what is the issue, what made you pass such a draft. So that is now in the public, as we know, it's there in the news, and this matter is pending. So the court is going to look at it, and will eventually look at all the aspects, and will be leaving it to the center, because union territories come under the administration, come under the direct authority and jurisdiction of center. So it will be, the onus will be on center. Central issue അവിടെ എന്താണ് അവർക്ക് ആവശ്യമുള്ളത്, അതിന് വേണ്ടുന്ന കമ്മിറ്റി ഫോം ചെയ്യുകയോ അല്ലെങ്കിൽ അതിനെക്കുറിച്ചുള്ള നടപടികൾ എന്തെടുത്തു എന്ന് കോടതിയെ ബോധിപ്പിക്കേണ്ടത് അവരാണ്. അത് ബോധ്യപ്പെടുത്തി, ഇൻ കേസ് കോടതി ഈസ് നോട്ട് ഹാപ്പി ഓർ നോട്ട് സാറ്റിസ്ഫൈഡ്, അത് തുടർന്ന് കോടതിക്ക് ഒരു വിഷയം, നമുക്കറിയാം പല വിഷയങ്ങളും ഇപ്പോൾ നമ്മൾ അടുത്ത സമയത്ത് കണ്ടതുപോലെ ഓക്സിജന്റെ ഇഷ്യൂ ആയാലും, അത് നേരത്തെ ബ്ലാക്ക് മണിയുടെ ഒരു ഇഷ്യൂ ആയാലും, ഒരു കമ്മിറ്റി ഫോം ചെയ്യാനുള്ള അധികാരം കോടതിക്ക് വന്നു. സോ കോർട്ട് മേ ടേക്ക് എ ഡിസിഷൻ ഓൺ കൺസിഡറിംഗ് വാട്ട് സ്റ്റെപ്സ് ഹാവ് ബീൻ ടേക്കൻ ബൈ സെന്റർ.
Yes. So anybody else want to ask questions upon this topic? Please, you can. Lakshadweepine sambandhikkunnayittulla legal doubts or something that related to judiciary and Lakshadweep, you may please.
Hello, good evening, sir.
Good evening. Good evening, Anaka.
Hello, sir. Sir, I wanted to ask you two things with respect to the Lakshadweep issue. Firstly, sir, sir, do you think that the problem here is more fundamental in terms of how the law which is made is not in tune with what the local population needs, especially because there are certain laws that seemingly affect the eating habits of a population which largely belongs to a particular religion. So, in such a case, do you think there is a fundamental problem? And secondly, I would also like to have your views on how the present changes would affect the decentralization aspect in terms of how the local government levels function in Lakshadweep. So on these two issues, sir.
So
Yeah.
to add on to that, I think there was a judgment by the Madras High Court on the issue of I think I do not remember the case now. The views of the minority and majority. The thing about a festival that was being conducted in a Muslim majority area. They wanted the festival to stop, and the court actually intervened and said it cannot be done so. So comparing that with the Lakshadweep, the majority of the population is Muslim, and I think
Hmm.
the
Got it.
explanation that is being given by the administration is that it can because it is a majority view, it cannot be the law. This is actually what is said in the case of the alcohol introduction of the alcohol and the beef ban that is going to happen in Lakshadweep. How this the judgment from the Madras High Court actually, I mean, I think you
Right.
got the point, right?
Right. See, you're all a very well-read group, and you people all analyze the issue from different angles. That I must say, and we all know that. So you've looked at the aspect of the population counting, and we all know that it's more of a Muslim-dominated territory, and there are things of that, and we know. So there is. It's easy to link the reasons with certain reforms or certain decisions or slew of rules and regulations which have been passed, which have been made. Yes, you can look at it different angles, but eventually what matters is we need to see if we are going to just analyze individually sitting here and there, it won't serve major purpose individually. If we just want to criticize or critically analyze it also, because eventually in such issues, what is really required is now that the court of law should decide, should really decide on these aspects, because we know that politicians will play their politics and they will raise this. They have been raising this issue, but it doesn't seem as if there'll be a resolution. The center sitting there, they've got the centers here, they've got the control there here, and no matter what is being said there, resolution or whatever shaking up is happening in Kerala, it really doesn't bother. Probably it might not politically, because they look at it in a political way. But what really will require will really bring things to right perspective is when what is the court's view on this? How is court going to look into it? Because the matter is pending before the court. It is before the Kerala High Court. Let the court decide on this. What is court going to see? Because see, the draft legislation is pending. The matter is pending before the court. So let court look at it from all angles, because court will be looking at it. Center is going to come. They will bring out their view, perspective, what made them bring out these reforms. One or two fundamental reasons that they have said is that they look at the possibility of turning Lakshadweep into a tourist hub, something on the lines of Mauritius. There is similar climate, there is similar environment, and there's this possibility of doing that, this, that. But then the other question was that why can you do that against the wishes of people? Now that is again a big question. If people at large are against it, as has been said now in the media, which is coming out here. Now, so those that's an issue. But how? But what exactly is the proof? The court is going to look at it on the basis of evidence. They will look at it in its totality, and then court will decide upon it. So that is the best approach. Like, we need to now wait and see what is going to be the view of center on this, and how is the court going to decide on this aspect. And it's better not to bring in the angle of religion into this, at least in a public domain, because as we all know, we are a country which takes pride in its unity, diversity, and secular ideals. So let's hope that the issues get resolved, whatever is there, and the beauty and the peace of the territory gets restored.
Yes, sir. I think Anaka, you had a second question, right?
So could you also tell us about your views on how these changes would have an impact?
And I think you were when you said the question first time,
Hello.
I did get it. You were trying to talk. You were referring about decentralization, right? You were talking about how it is this will
Yes,
have an
sir.
impact.
Yes, sir.
Impact,
Exactly.
yeah. How this will have an impact on the local bodies which are
Yes,
there.
sir. Yes, sir.
Another,
The same.
yeah, I got the point. I got the point. So if you look at it, the reforms that have been rolled out, what is the impact of it? If you look at it, the administrative setup of Lakshadweep is there is an administrator, then there is an advisor who's the second in command, who has got a lot of departments under his control. Then there are other secretaries, private secretary, IS officers who are there, or secretaries who are there, and in that hierarchy it follows. But then, since it's a union territory, it's one of the union territories of the country. It has its own distinct way of administration. That the administrator is not the sole authority who administers also. He is accountable. The Home Ministry is there, and that is the case with respect to a law also which is passed. Like for example, if this LDAR law that we are talking about, the Land Development Authority Regulation, this has to get the sanction of the Home Ministry, and then the cabinet has to approve it. So this whole there is a dynamics which is involved in this. So you cannot expect any change that is going to happen with whatever has been which has happened right now. This process will remain intact.
All right, sir. Thank you. Thank you.
Any further questions? If there is any further query, you can ask now. Okay, sir. Then we'll move on to the next topic. I think the last topic is about yes, reservation. Yes, sir. So I think this is a hot topic. First question is actually about the Maratha reservation. What was the rationale as he actually used to strike down the reservation for Maratha that was actually given by Maharashtra?
Now another hot topic, which is there in the public domain again, discourse, but this has been there for a quite long time. We all know that for years this has been a part of our national discourse. Reservation, if you look at it, has been a topic when the constitution framers they framed the constitution itself. At that point of time, it was seen whether reservation is required and to what extent is required. There is a view on the basis of the there's a view that it is only for 10 years, and that also for reservation was only for uh, reservation is only for 10 years. That was one view. But later on, with the by interpreting articles 15, especially article 15 clause 4 5 and article 16 5 6, and those specific provisions which are there for advancement of backward classes, uh, the so-called scheduled tribes and scheduled castes. So because of that, keeping that provision in mind, we've seen that reservation has reserved seats have been reserved in education institutions, seats have been reserved in jobs and employment areas. So that is there, and the objective ultimately has always been to ensure that those who are backward, they reach at the same pedestal, and they have the same opportunity, so that both so people who are don't have the means and mechanism, they also reach the same level, and then they can enjoy the fruits. So this is ultimately the objective, and this has also come from the age-old history of India with the Varna system and everything, which we all know, and I don't want to go into that. So this brings us to the issue about, and then later on we know that how OBCs were also included. So around 27% of reservation is there for the OBCs, and with the Mandal Commission report also that was there, which was a big major news, and how creamy layer is only included in the OBC category. So this discussion has always been there in the public domain, and this was specifically the judgment which deals with this in its entirety. സമഗ്രമായിട്ട് ഈ വിഷയത്തെക്കുറിച്ച് നന്നായിട്ട് സുപ്രീം കോടതിയുടെ ഒരു വിധി ഉണ്ടെങ്കിൽ, ഈ വിഷയത്തെ കൈകാര്യം ചെയ്യുന്ന ഒരു വിധി ഉണ്ടെങ്കിൽ, അത് ഇന്ദിരാ സാനീസ് ജഡ്ജ്മെന്റ് is the one. Now we look at this 1992 judgment, Indira Sani's judgment. This one judgment which has set the benchmark. It said the numbers are clear. ഈ എത്ര പെർസെന്റേജ് കൊടുക്കണം എന്നുള്ളതിന് വ്യക്തത വരുത്തുന്ന judgment ആണ് Indrasani judgment. It says that 50%, there should not be more than beyond 50% reservation is not constitutional. So this has, and everything that has followed after that has implications, and it follows other Indrasani judgment basis ലാണ് എല്ലാവരും അതിനെ ഓർത്തുകൊണ്ടായിരിക്കണം ഓരോ തീരുമാനങ്ങൾ എടുക്കേണ്ടത് എന്ന് policy makers അറിയാം. And that is why when we look at this Maratha reservation which has come, the court has struck down Justice Chandrachud's bench. They looked at it in its totality. They looked at it, they said that, look, this Maratha reservation is not in sync with the Indrasani judgment. Why? Because if you're going to give Marathas also reservation in your state, this will take up the level of increase it to beyond 50% reservation, and this is not constitutionally acceptable. So that is a reason why this has been done. The basic major reason for denying Maratha reservation by the court.
Sir, in that case, we also have a new kind of reservation that came into effect, I think, in 2019. The economically weaker sections were also given reservation. I think I do not know what the status of that the economically weaker section reservation is in the courts. Wouldn't it violate actually the Indrasani judgment of 50% reservation?
Can you repeat the last lines that you just said?
Yeah, the economically weaker sections reservation is actually 10% for reservation for the economically weaker section,
right,
over and
right,
above the 50% that has been already given in Indrasani judgment.
Right.
So wouldn't it actually violate Indrasani judgment?
No, in this case, Shobit, what we need to look at it is that when the former late finance minister, Mr. Arun Jaitley, when he proposed this bill which was aiming to grant EWS category as a reservation, he said that Indrasani judgment will not be applicable to it because it is caste-based reservation. That is what the judgment is talking about. So with that much, when you look at it, 50% reservation is only based on caste-based. But economically weaker sections, economically weaker society, a person from EWS category will not fall in that category within, or that category will not come within that 50% ambit. So we can provide reservation for EWS. That was his point of view, which when this proposed amendment was brought in, the 103rd amendment, if I'm not wrong. Am I right? I think it's 103rd amendment. So this amendment, so that was the reason that this was brought in. Now this matter is sub judice. It's before the notice of Honorable Supreme Court. It's before the purview of Honorable Supreme Court. So let's see what the decision will be. But this was the viewpoint. This was the viewpoint of the government.
Yeah, I think, sir, it is already being applied now. Even if it's sub judice, I think even in the UPSC examinations, the EWS category is actually being applied right now, as per the law. I think, sir, can you give us your views? If is the EWS reservation system actually justified as per our constitution, or is there something amiss there? I mean, I know the matter is sub judice, but just asking for your views on it.
Shobit, I would not like to comment on this because this matter is sub judice, but I just want to say that, see, reservation is an issue. It's a touchy issue. It's a touchy issue, and it's very difficult. But the point is that if there is a 50% category, caste-based, that should not go beyond that. But economically weaker sections, how will you categorize it? There are a lot of issues involved in that. We'll have to look at it. I've not thoroughly read that constitutional amendment bill, but it's important to see how will you categorize people who are, whether they are economically weaker or not, and what will be the parameters. So how will you do this, and how? So there is a lot of issues involved, and when you give them the EWS category, if they are going to be, if the SC, STs and people who are already, or the OBCs, if they're going to be excluded from the category, will it be a fair treatment? That there is another question which is beyond, which is there. Economically weaker sections. So there are issues which are smaller issues which are there, which needs more of understanding, and and a very crystal clear scrutiny is required. अब അത് കോടതിയുടെ purview-ലുണ്ട് and court will look into it, and I'm sure they will come to a fair decision as to whether or not it is acceptable, and if it is acceptable to what extent, and how, what are the modalities, how will it be implemented. These things will come out for sure through the judgment. At least we'll get a fair idea, I'm sure.
Yes, sir. I think the Karnataka and Tamil Nadu also has this 50 percentage, above 50 percentage reservation in jobs, I think, sir. So I think
So that,
Tamil Nadu has 67 and Karnataka has 74 percentage reservation, I think, sir.
so so that would be the reason. I think they must have got a proper legal advice that look, 50% is the cap for caste-based reservation, and so the rest, I think they've given it for financially weaker sections. So they would have taken a proper legal advice and they've gone ahead with it. But then we'll have to see now, because this is a central act, and this we are talking about a constitutional amendment here, which is before the purview of the constitutional bench. So let's see what comes out of this, because this will affect the nation at large, as a whole. So this is what is most important. So let's see how it goes.
Yes, sir. So I think if anyone else has a query, you can ask it now about reservation or anything in general relating to the judiciary. I think you can ask any question. Yes. Anybody is there? If there is any query, you can ask right now. Okay.
Hello, sir.
Yes. Yeah.
Sir, sir, I wanted to know your views on the high number of judicial pendencies in India. Why do you think we have so many pending cases, and what do you think is the way forward to solve it?
That's a good question. This is again an issue which is there in pending before the courts as well, but in the purview of courts, and it's part of our public discussions as well, as to why is there this big backlog. Now, if you look at it, there is the major reason at that point of time was that, as we all know, that before Article 323A, 323B, before the tribunals came in, the burden on the courts was immense, and that's why you know that tribunalization happened, with tribunals then being set up. The burdens then started shifting to the courts. But then you have specific tribunals which have been formed for issues which earlier was all being burdened before the court. So the court was unable to dispose of matters because of that. Now, since you have specific tribunals coming already there in place, specific issues connected to specific streams of law are before the tribunals, and the tribunals have their jurisdiction and they're hearing those matters. As a result of that, disposal rate has increased. Now, if you look at it, the last 5-10 years records, you'll see that the cases that have been filed recently, like the last 5-10 years, they have been decided. They have been getting decided quickly. The disposal rate has increased, no doubt about it. And from somebody, of a new generation lawyer, I can say that to you people, that the cases that have been getting listed, getting listed quickly. It's not like what it used to be in the past, that cases took time to get a case listed for hearing. And also the cases are getting disposed of also quickly. The courts are not inclined to keep those matters pending. They are more inclined to dispose of quickly and settle the matters. That's what we are seeing now. So that the attitude shift has come. But whatever was there, whatever is pending, there is a backlog, but attempts have been made. The courts have given directions in the past. They've said that whatever matters are like 10 years old, those cases need to be disposed of. ആ പഴയ കേസുകൾ 10 വർഷത്തിന് പഴയ കേസുകളൊക്കെ കിടക്കാൻ പാടില്ല, അത് തീരുമാനം ആക്കണം, അത് ഫിനിഷ് ചെയ്യണം എന്ന് പറഞ്ഞിട്ട് തീരുമാനം കോടതി പലപ്പോഴും പറഞ്ഞിട്ടുണ്ട്. Right.
Sir, a question. I mean, this is not actually related to preparation or anything. Yesterday, actually, I was watching the movie Dhananjay, a Bengali movie that is recently released in 2017, I think, about a convict who was hanged in 2004, I think. 2004, August 15th, Dhananjay.
Yeah, it was a rape. Convicted. Convicted.
So the movie is actually based upon. The movie is actually giving him a retrial and saying and giving him the benefit of doubt. The courts actually failed to give the benefit of doubt to the particular convict. I do not know if you have heard about the movie and theories.
No, I've heard about the case. I've
Yeah.
heard about this case. I know it very well because I remember this case. Yeah, I've not heard the movie, but yeah, if you, as you're saying, so if you're trying to ask me like, should the court should a court taken a decision like that of hanging him to death? Was it premature? Are you asking like something like that?
Yeah, sir. Actually, he actually spent. The issue is more of like a media trial and the society. What the court actually takes into consideration the public opinion. I mean, what the society generally thinks at the time and all. Such things are actually said in the movie. I'm not sure if it's. I mean, because in 2004 I was not following the newspaper that well,
Hmm.
so.
Hmm.
Uh, I do not know if I have heard that there was a very large public uproar during that time to get the punishment for this particular person. And I think Buddhadev Bhattacharya's wife actually took out a campaign to ensure that he is hung from the nook. Uh, so, uh, so what happened is that I
The
think
public sentiments.
he actually spent 14 years in prison, and even after that he was hung by the nose. So the
Got it.
issue of this, even three courts actually confirmed his death penalty, and even the president also actually,
Mercy petition was also dismissed.
yeah, mercy petition was also dismissed, and actually there was no direct evidences; it was all circumstantial evidence. So is this actually a miscarriage of justice?
It's a tough question. See, this is again, it will depend on case to case basis. Like we need to thoroughly see what the case exactly was. Like what comes before the public it will not be what is the real truth. It may or may not be. But the courts generally go by what the evidence is, what is and in case of criminal matters, yes, if they don't have a direct evidence, then they will look at the circumstantial evidences. But what exactly the circumstances point to the fact that this person, the accused, is guilty of the crime, then they will convict him. Now, as far as the sentencing to death is concerned, hanging to death is concerned, the capital punishment is concerned, it generally the courts do this in case of rarest of rare cases. That is the principle. When there is a crime which has happened, which is kind of a rarest of rare crime, in those scenarios. Now, did this case fall in that category? It is difficult to just say right now as to without understanding the facts and circumstances in its entirety. But the courts have generally, three courts have not overruled. He went each before each court, for the Sessions Court, before the High Court, before the Supreme Court, they all have upheld his conviction. Then the judges, you cannot say that look, there was no application of mind or there was miscarriage of justice, because that will be a very very vague and inappropriate statement to make, because if judges, after each judges in that hierarchy, if they have gone ahead and they have convicted it, then they've looked into the aspect for sure in its totality and the impact of the crime in the society at that point of time. Like in 2004, when this crime happened, it was a major newsmaker. It had a major impact. Children, parents with daughters, it really affected their psyche, the crime that happened and the circumstances in which this happened. So became a major news, like in the case of Nirbhaya, what has happened. So the court generally will look at that aspect also, like the impact, the social impact would also must have been taken as a factor into consideration.
Sir, but if he was really innocent, then
Yeah.
killing someone for just for the social, for the society. I mean,
But
I always
that's not.
believe that.
But we cannot say that now, because the courts have gone into it. That a filmmaker has
Yeah,
made something. He's done it from his end. But how much of material did he have with him in his disposal? Did he see everything with him, or just from? We all know that commercialization is there, and people make it, and they want. End of the day, who doesn't want money? And when you pick up a sensational issue, everybody would like to pick up a sensational issue, because that will help in minting money. But what is the truth? What exactly are the evidences which are there? It's there for the courts of law. The records would speak for it. The judgments speak for it. And I think we need to look at that. Though I have not examined that judgment, but it only when we go through that, we will definitely will get a fair idea as to what made the courts convict him.
yes, sir. I would also like to know your perspective on capital punishments.
Capital punishments.
Yeah, a capital punishment as such. Should we have it as a civilized society or not?
See, capital punishments in the rarest of rare cases. I will not. I'm not. I won't say that there should not be capital punishment. I'm not in favor. I'm not somebody who will say that no, there should not be capital punishment at all. But then, when are you going to give capital punishment? It's like the rarest of rare cases. The Supreme Court has also said in those scenarios when the crime is extremely grave, there are judgments to that effect also. There are a lot of judgments. If you just search, the courts have in wherever the courts have given capital punishment, they've analyzed those judgments. They have looked at it, and in the extreme of extreme cases, only then courts have decided to give capital punishment because of the offences of that nature. Because when you give capital punishment, yeah, the intention appears to be that nobody should commit that offence again. So that is, and then the impact of it, as I said before, on the society, the consequences of it. So all of that is looked at. So that in that respect, at the rarest of rare, and very judiciously and very wisely, I think the judges also do that. I mean, we're not hearing too many of capital punishment being given. Whatever the cases are, they hardly like to in that 20, 30 cases. I mean, not many cases are there of capital punishment. Those capital punishment cases, maybe it's a handful of them, like the one that you pointed out. There could be some exceptions which there could be debatable, but more or less, in most of the cases, capital punishment have been given are cases where the offender or the person who's convicted had really committed a grave crime.
Yes. If anybody else want to ask a question, you may please. Anybody else? You have to. You have a query.
I think too much of a talk. I think too lengthy a discussion. Probably people are all tired of hearing me speak on.
No, I mean, yeah.
So could I ask you one last question, sir? One last question.
Yeah, please.
Yes, Anaka, yes.
Okay, sir. Sir,
Yes,
what are your views on the very low representation of women in the higher judiciary? Because the numbers are very abysmally low. At the Supreme Court, we have just one woman judge. There's just one lady chief justice of a high court in the entire country. So, what do you think is the real reason why women are not sufficiently represented in the higher judiciary, at least compared to the lower judiciary?
Yeah, it's a good question.
Is it just a reflection of the larger social issue where social inequality, or is there anything specific to the legal profession that creates additional barriers for women in stepping up in the judiciary?
No, see, if I will not be hesitant to say that there was a time when legal profession was seen more, especially litigation. Litigation side was seen more of a profession which is meant for men, and there was this false perception, which was there, that's because it was like that. The society and those lady lawyers who made really mark at that point in time, they should be saluted also because. Like Lily Thomas, late advocate Lily, senior advocate Lily Thomas, madam. She's somebody of that generation. So there are people like that, Srimati Indira Jay Singh, or some people, women advocates like that, who have seen those times, those hard times, and when the just legal profession was dominated as such, if you can say. But that has been broken. The perception seems to be changing now. There's a positivity that's coming up. The judges have openly come up and said that the representation should be fair. That representation fair. So we are going to see change in that. We will see. I'm very positive about it, and we would like to see women judges also in the bench, because more women coming in the bench, because they bring in a different angle altogether, a perspective which is very required, the humane side of it, sentimental side of it. So they've got more grip on those on those aspects. So it's important that women judges are there more in number, and we're sure that representation will increase for definitely. But in the lower judiciary, I've got a lot of my friends who are judges in lower courts, and they're doing really well. And we can see positivity happening. We've seen in the Delhi High Court, I must say that there are a lot of women judges, impeccable judges, and very good, eminent judges who are from Bar. Justice Pratibha Singh, Justice Jyoti Singh, they've recently been elevated as High Court judges. they are there in the High Court, and they're really impressive, the judges who have come from the bar, and they're getting elevated as judges of High Courts.
I think recently, I do not remember if it was Chief Justice Bobde or Chief Justice Ramna. We need a lady Chief Justice. He has actually
Yes,
come
you're right.
Yes.
Right, yeah. During his farewell speech, I think he said that. Yeah.
Yes.
Yeah.
Okay, I think if there are no further questions, we'll wind up the session. Any further questions you can ask now, or we'll wind up the session.
I think I'm grateful to the organizers for giving me this opportunity to talk to such an erudite, scholarly group which is there. As I said in the beginning, I had my own heart nervous feelings. Like I felt that how would I be able to, will I be able to manage it, and the question that will come will be very hard, and I've not thoroughly researched also, but somehow I felt I'm happy that to got the opportunity to interact and to hear your views also, and have a healthy one-on-one discussion, which is very important. So, and that's why I think we've been able to stretch it to almost 2 hours. Because otherwise, it will be very difficult to digest hearing somebody speak, and one-on-one having a unidimensional speech would be, it's very difficult.
Yes, sir. So we, as UPSC aspirants, we all have a very, I think, I personally have a very bookish knowledge. So when we get to speak to experts who are actually working on the ground, I know you are involved with PILs or several issues in the High Court as well as in Supreme Court. So speaking to the people who are actually experts and who know the real ground, what is happening in the ground, that actually gives us much more better dimensions further on in our preparation. So speaking to people like you are actually enriching our knowledge for the better. So sir, thank you for having.
Thank you for having me. My best wishes to all of you, all the UPSC aspirants. I believe there are some people are waiting for interviews also. I think just do your best, give your best shot. Don't take any tensions, and just be confident. And when you face an interview, just be bold and confident, and have a positive frame of mind. That's very important. I'm sure all of you will do well and in life with in flying colors. With flying colors, and you'll all be UPSC. You'll all crack UPSC exam, and you'll do all civil service. I hope and pray that.
Thank you, sir. Thank you so much for being with us today. I think I'll ask Jojen to end the session now. Jojen?
Sure, I will end.
Yes, Jojen, you can end the session now. Thank you, sir. Thank you so much.
Pleasure, Shobhi.